Mr. Boyle, good morning. Is it Mr. Boyle you're going
Mr.
for?
White, Your Honor.
Oh, Mr. White, I'm so sorry. My clerk is in fact very accurate. It is. I'm so sorry.
That's
Mr.
okay.
White, good morning.
Thank you. May it please the Court. This is an appeal taken from an order of the trial court denying the appellants John T. Callahan and Sons and Zurich American Insurance Company's motion for an award of attorney's fees for successfully establishing Worcester Insurance Company's duty to defend in an underlying tort action. It is the position of the appellants in this case that the progeny created by the Gamache ruling, as well as Rubenstein, Golden, and Wilkinson, that our clients should also be awarded attorney's fees in this matter. The rulings in Gamache, Rubenstein, and Golden all create a consequence to an insurer who fails to acknowledge its duty to defend an insured in the Commonwealth. It also creates a discouraging factor for insurers that do not adhere to their benefit of the bargain in defending a party. In this case, there was concurrent coverage relating to concurrent coverage between Zurich American Insurance Company and Worcester Insurance Company provided to Callahan. Zurich was a primary insured under a policy of insurance purchased by Callahan, and Callahan was an additional insured on a policy of insurance purchased by one of Callahan's subcontractor. The underlying tort in this case related to a construction accident wherein both Callahan and its subcontractor were sued.
Can I ask you this? Looking at Wilkinson, for example, versus Citation Insurance Company, and trying to apply that case to this case, here, you looked to recover both for the insurer's failure to defend and for the insurer's failure to indemnify.
That's correct.
And at least with respect to
and we were successful.
Right. And at least with respect to the indemnification part of that claim, aren't you sort of out on Wilkinson? Don't we say that you can't get attorney's fees for that?
Possibly under Wilkinson. The Wilkinson decision does distinguish Safety versus Day, which did allow that on the indemnity factor. However, parsing them out in this case, I think you really can't do. It was primarily a duty to defend case, and they significantly waived the indemnity issue by not defending and not taking part in the settlement in the underlying case. And in that case, Zurich and Callahan agreed to settle that case. Zurich paid the fees. Since the ruling of the trial court, implicitly, the judgment has been satisfied by Worcester Insurance Company. So the remaining issue is whether or not a fee award is applicable in the case. I'm not sure if that answers your question.
Well, I mean, so you're saying that, yes, Wilkins, if this were simply Worcester Insurance Company refusing to pay on the policy, and you sued Worcester Insurance Company saying, no, they should pay and contribute to this settlement, that under Wilkinson, you would not, even if you won that, you would not be able to get your attorney's fees.
Well, we wouldn't.
I mean, I think that's what Wilkinson means here. But you're saying that this is really not that case because it was in part also a failure by Worcester to defend, and therefore under Wilkinson you would be able to recover those fees. And since they didn't defend, then you should be able to recover fees both for winning the duty defend part and the indemnification part.
Well, that's partially accurate, Your Honor. My point with addressing Worcester's non-involvement in the underlying suit was to demonstrate that the indemnity issue became a non-issue after they did not participate because the fact of the matter is they were no longer allowed to control the indemnity payment as part of the underlying tort to the tortfeasor in that case. I.e., they didn't participate in the settlement, although they were present. They didn't provide any money. They certainly didn't defend or offer counsel to Callahan at the mediation that ended up resolving that case.
But the damages that you got in the suit
Yes.
against Worcester. They were compelled to contribute to the settlement and to the cost of defense?
They were compelled to contribute equally to both, and they have done that since the judgment
But I
was
take it
entered.
you're saying that the time that was spent in providing legal services to Callahan in this case can all be attributable to the failure to defend.
Absolutely, in this case,
Yeah.
in the declaratory judgment action, that's what was being pursued. Like I said, there were concurrent coverages, and they took the position that they were an excess coverage.
And you're subrogated to the rights of Callahan.
That's right, absolutely, and that's our position in this case, which is opposite to the position of the trial court and to Worcester's position, and that position is that this court has never said that attorney's fees can be recovered by an insurer on behalf of an insured who challenges another insurer, and that's the argument that Worcester makes in this case. The declaratory judgment action was brought not only by Callahan but by a Zurich insurance
But
company.
did Callahan himself have any costs?
They did not, Your Honor.
No. So in effect, it's being brought by you.
In effect, Your Honor, if we didn't bring it, Callahan would bring it, and then I suppose we wouldn't be here.
Well,
Well, but Callahan wouldn't need to bring it because it had already gotten defended by you.
That's correct, Your Honor. Your question implies that parties, insurers, or counsel could implicitly create a bookkeeping exercise wherein the fees, for instance, were paid by the insurer on a backroom agreement, so to speak, with an insured where the fees would be paid by the insured, and there would be an agreement with the insurer that no one knows about, and then they apply for the fees with the court. The court grants them fees, and then the insurer compensates them for whatever they outlaid.
But if you say, if the court in this case says, yes, you can recover your fees, Zurich, does that mean for every declaratory judgment action between insurers over whatever, or you would limit this only to duty to defend a common insured?
I think it should be limited only to duty to defend a common insured, perhaps even where there's concurrent coverage. Here, as in many construction accident cases, there are different levels of insurance provided to the different levels of contractors at the site. Here, our client, John T. Callahan, was the general contractor who had his own layer of insurance. Below him, New England Air Conditioning added him as an additional insured as a subcontractor, creating a second layer, and there were even layers below that with respect to subcontractors that were hired by New England Air Conditioning, who also provided insurance, additional insurance to Callahan. There was initially in the declaratory judgment action a third party, a third insurer who paid for the indemnity and actually settled part of the case on their own after they realized that they had concurrent coverage with Zurich in this case.
You mentioned several cases from other jurisdictions on pages 15 to 16 of your brief.
Yes, Your Honor.
I took the time to look at them, but they really don't discuss why one insurance company should be able to be awarded fees against another insurance company. They do, I mean, I agree with you, they support your position to some of them, to some extent, but they don't ever discuss why or give any reasoned discussion of why they're making the award or affirming the award.
You're right in that we do cite cases from outside of the jurisdiction, and I do that because most of the controlling cases in Massachusetts refer to those cases in Maryland, for instance, the Hayseeds case, and they do that as guidance. I would say that Travelers versus Insurance Company of North America, 517 Atlantic 2nd, 760, does talk about that issue, Your Honor. And it says specifically not only that the insurance company is inured, subrogated, if you will, to the full package of rights of the the insurer is subrogated to the full package of rights of the insurer, and I think that's a clear discussion in that case.
But do they explain why?
Well, I think it's all, that position is also explained in case law in the Commonwealth, specifically the, excuse me,
I'm sorry, what page did you cite on traveler's indemnity?
519 Atlantic 10760.
No, that's the
I'm
site of
sorry.
the case. What page are you referring to?
Of your brief, is that what you mean?
I think it's in my
What page
brief,
of
Your
that
Honor.
case? I know it's in the brief. I have the case. What page of the case are you saying this contains the discussion? If you know, if you don't know, that's fine.
I don't know offhand, Your
That's
Honor.
fine. Okay.
I apologize.
That's okay.
All of the cases, though, both within the jurisdiction and outside of the jurisdiction, suggest that a penalty should be issued to the insurer who is wrongfully declining coverage. And I think that Justice Spina said in the Hanover ruling that where there's an abandonment by an insurer to defend its insured, that a penalty should exist. And in Hanover, of course, the court ruled that the party was that fees in the DJ action were applicable to the party who was abandoned by their insurer. That's exactly what happened here. Worcester abandoned its insurer. Whether or not Zurich stepped up to the plate, which it did, and defended it all the way through, should not be at issue.
So you disagree with Judge Chernoff's distinguishing between consumer protection and company?
I do, Your Honor. I don't think that distinction has ever been raised in any of the court's rulings thus far, Gamache, Rubenstein, Hanover, or even Wilkinson. He does make a distinction in that case that the exception to the American rule created by Gamache only applies to consumer versus an insurance company issue. However, cases outside of the state, as noted in our brief, many of them deal with not only corporations versus insurance companies, but also other insurers versus, or insurer versus insurer in that context.
So you're basically, I think this is what you're saying, which makes some sense to me, that if you look at this from Worcester's perspective, when it doesn't step up to the plate wrongfully, it has injured its insured. The fact that serendipitously another insurance company came in and solved the problem for the insured shouldn't mean that Worcester gets to go home scot-free.
Yes, Your Honor. It would be a brash consequence to now allow an insurer who didn't step up to the plate, who wrongfully decided not to defend its insured, to then allow them to walk away scot-free, so to speak, from the declaratory judgment action because there's no penalty involved. It's foreseeable that insurers would take that position wherever, take a declination of coverage position wherever there's concurrent coverage, and that they would just hedge their bets on the DJ action, knowing that they wouldn't have any.
They wouldn't lose any more.
They wouldn't lose anything in the DJ action.
But the
So
rationale...
that if they order to defend, fine, they go and defend.
Yes.
And if they don't, all the better.
Right. There's no loss to them.
But you would agree, Gamache created an exception to the American rule, and the reason, the rationale in Gamache for creating the exception to the normal American rule was that arises from the contractual relationship between the insurer and insured. And here, there isn't any such contractual relationship, is there, between the two insurance companies?
There is not, but as stated earlier, the insured in this case, the insurer is subrogated to the rights of the insured, and I would argue
No, but
those
as I
include
stated earlier,
contractual
but the
rights.
insured didn't suffer any,
But there was wasn't Callahan named as an additional insured on the,
Yes,
so it's sort of a third-party beneficiary of that contract.
I suppose that's correct. Your Honor, I have no further inquiry. If you have no further inquiries.
Thank you, Mr.
you.
White. Mr. Hassett?
Thank you, Your Honor. May it please the Court, my name is Attorney David Hassett. I, along with Scott Ober, represent the appellee Worcester Insurance Company. I'd like to start with the fact that in the DJ action, Worcester had judgment in their favor on the 93A case. And Judge Chernoff specifically found in his ruling that it was a worthy issue advanced by Worcester Insurance Company regarding the two competing policies at hand. Going back to the...
And so what you're saying is if there's a reasonable belief, you proceed at your risk, correct?
Yes.
But where there's in other words, if there's no additional insurer in the picture, right, you proceed at your risk, your insured can bring an action against you, and if you lose that, you can be penalized substantially, right? I mean, either you have to go to defend, and you may even be faced with a 176D or a 93A.
Yes.
Okay? Here, there's really no risk, correct?
I don't think that's correct, Your Honor. I think
Okay.
two responses to that. First and foremost, if you look at the record, Worcester Insurance Company had to contribute 50% to the defense costs and 50% to the settlement that they...
Ultimately, that's true.
Ultimately, that's true. And the issue, this is not an uncommon issue between insurers. When you've got multiple policies covering the same risk, you are invariably going to be taking the other insurance clauses, as insurers do all the time, and compare them. And the different clauses are pro rata, they're excess, they're escape, they're super escape clauses, and that's what was done in this case. The issue, I think, before the court with respect to this decision, and we urge the court to affirm and uphold Judge Chernoff's decision, is because what the plaintiffs have done, in essence, they've circumvented the reasoning and the public policy considerations for Gamache by simply naming Callahan in this case. This isn't about the insured versus the insurer. The special relationship that Justice Cowan just spoke to doesn't exist. And furthermore, the reasoning for the Gamache line of cases was because it was felt to be unfair for an insured who paid premiums for both defense and indemnity to essentially lose that if they had to incur themselves the cost of the declaratory judgment action.
Yeah, but for the fact that Zurich stepped up to the plate and defended Callahan, Callahan would have had to incur the expense of defense out of his own pocket, and he would have then gone after both insurance companies.
But Judge, they had the obligation, Zurich had an obligation. There's never been an issue here about Zurich. So in essence, I would say Zurich has the obligation, no issue. They're the primary insurers. All this is about is Zurich saying, we want contribution. We want to get help. This isn't about Callahan.
And
You're
you're
saying that this is really a case between two insurance companies.
Precisely, Your Honor.
But
you're also...
if Zurich did not defend, if Zurich did not step up and defend, and Callahan had to have defended himself, he could have gone against Worcester exclusively, couldn't he?
In theory, he could have.
Okay. So why should we be rewarding this, what essentially amounts to a game of chicken between a couple of insurance companies?
I don't know that it is, Your Honor, and I wouldn't characterize it that way, because in an instance like this where one insurer, and certainly the record shows it was a worthy issue presented with the two clauses. And
Yeah, but that could always be the case. That doesn't seem to me to be
Well, I guess your position, I think your position is, if Zurich had, they're the primary insurer, no
Yes.
question. So if they hadn't defended, they would have been socked with
bad faith.
bad faith.
Easily.
Right? So where you've got one clear, I assume, insurer, right, and there's a reasonable judgment as to whether the other two, whether the second one should cover, that's not where we should be awarding fees. If there are two insurers where it's unclear, so you may have two insurers where it's unclear, to take Justice Spina's example, and the insured sues both, and it turns out that both had a duty to defend. What do we do in that case? We give the insured attorney's fees, right?
Yes, and if I can just follow up on that one
Yeah.
point, the rationale being in the Gamache line of cases sets it forth as the core for the exception to the American rule is that it is not proper with the special relationship between insured and insurer to have an insured have to litigate the duty to defend because it would undo the benefit of their bargain. And all the cases talk about the loss of
Your point, I think you made this, is that, I just want to get this factually right, that Callahan paid no premiums to Worcester. Is that correct?
That's correct. They were an additional insured on the contract.
So that
In the underlying
So Worcester's insurance relationship, direct insurance relationship, is really who paid their policy, and that would be the subcontractor. Is that
Yes, and I think the Gamache line of cases is based on the public policy reasons that do not fit and will never fit insurers who are debating the competing policies and the priority of the competing policies. Who's going to pay first and how much? And Gamache was never contemplated to start having insurers pay one another. Insurers are in the business of risk. They get sued, they sue, they do it often.
I take it, excuse me for interrupting, Mr. Hatch, but I take it in this case, right, in this case, if Zurich had not stepped up, then your risk analysts decide whether or not you better go in to defend, right? Let's assume, and because otherwise you may be at risk, correct?
I think potentially, Your Honor, to answer your question, if I think I understand it properly, that first and foremost, in our case, Zurich was in within the month.
No, I understand that, but let's assume that you had an insurer for whatever reason, you know,
It doesn't step up.
doesn't step up. Then I assume you decide whether you want to run the risk of having an insured sue both of you.
That's correct.
And you figure that one out.
That
And I'm
could
sure
change.
if they hadn't stepped up, you would have been doing whatever, impleading them or adding them as brought a third-party action. You would have done something to
It's a
get them in.
valid point that it would change the analysis, and
Sure.
it would be a different analysis potentially if that were the case, that the insured were not defended by anyone. In our case, it was clear they were being defended from day one, and it was clear they were going to be indemnified by the primary insurer. The issue was Worcester required with the other insurance clause when compared with Zurich's other insurance clause to defend. And Worcester determined on a good faith basis that they were not and didn't come in. Now, when the DJ is brought now, it's not brought by the insured, it's brought by Zurich, who is looking now for contribution. That's a far cry from what was contemplated in the Gamache line of cases. And it's clear that the Gamache line of cases in creating this exception, all the way now to citation, 2006, the most recent one, where this court has explicitly said, we're not extending this beyond the insured, insurer, and the duty to defend. This court didn't even want to consider it in the context of the duty to indemnify, even though there's an argument that similarly, if an insured has to sue to get indemnification, they're losing somewhat of the benefit of their bargain. But the court said, no, we've created the exception, we're going to maintain it.
But the exception, the key to the exception is, it comes up in several of the cases that arise out of that line. In this respect, liability insurance is litigation insurance as well. And if one of the reasons why, that's the point I wanted to make. But let me ask you this question: is it significant to your case that Callahan was an additional insured and not a policyholder who paid the premium?
I'm not sure to the extent that it would create any other rights, Judge, other than I would say there's no special relationship to begin with.
But he's still an insured. You're
But he's
saying
an
this is
additional-
Gamache is all about insured versus insurer. The insured could be the General Electric company. It doesn't have to be Joe, the radio repairman.
Or the plumber.
He's an additional insured, but he hasn't incurred, the insured which is what Gamache contemplated and was the public policy reasons for making the exception, he hasn't incurred. That's what's
I
the
understand.
difference in our case.
But he hasn't gotten what he bargained for.
Yes, he has.
And what he bargained for
He has.
was to have two insurance companies step up to the plate.
Judge, in all due respect, it doesn't make any difference to him. We know Callahan doesn't care about this litigation today. Callahan was defended from day one. Callahan had his case settled. He's long gone.
But if he didn't care, why did he ask to be additional insured on a policy?
To the extent that that insurance potentially had extra coverage for him, why not? There's always going to be a situation where more insurance is better than none, technically speaking, but once he knows he's being defended and will be indemnified, he doesn't care. What I would submit, Judge, that this is all about is about an equitable subrogation, which is a theory that allows presently insurers who feel they have paid more than their share to bring suit against other insurers.
Okay, let me just put the shoe on the other foot. Supposing it was Worcester who defended Callahan because Zurich didn't want to do it, would you be making the same? Would you be making the same argument?
I'd make the argument to the extent that I was looking to have half of the defense cost absorbed or contributed to, if that were my objective in bringing the DJ, and certainly half of the indemnity. But I would respectfully submit that under Massachusetts law, as an insurer, I'm not going to be able to get the cost of my DJ. That's the American rule, and that is way outside of the exception.
Okay, I have a question. I'm referring again to the cases from the other jurisdictions. Do you have any cases that rule in your favor from any other jurisdiction?
Not specifically on point, Your Honor, with this issue, because the uniqueness, I believe, of the Gamache line of cases is that it's been so narrowly defined now with Wilkinson. And I believe the wording is we are now expressly limiting this exception, that this court, in order to maintain that, needs to affirm the decision below in ultimately saying, as between insurers, this would open up a floodgate of litigation. It is very common for insurers to have disputes about who covers, what the priority is, and how much. They have never been able to recover their fees before, and they're always obviously involved with an insured somewhere in the chain. So in essence, what you would be doing, if you accept my brother's argument, is to say, going forward now, we want to make sure that any insurer who prevails in a complex coverage action will have their cost of their DJ paid. And that goes against the Gamache reasoning, and it advances none of the public policy considerations that formed the basis for that line of cases. Thank you very much.
That was quick. Thank you. Thank you, Mr. Hassett.